Yep.
Hi everyone, good morning. Today is another session of our roundtable with HR specialists and employment lawyers from the Seven Oaks community. This is something we hold on a fortnightly basis. We just discuss hot topics within employment law, any issues that we are struggling with at work or a client is struggling with is discussed here, and hopefully that will be of benefit to any employers or members of the chamber who are listening, who will listen to this recording going forward. So we've got our regular guests here from Tucker Williams, Dr. Foskett, my client from Peeran, Kerry, who's from Western Mind. We are waiting for a couple of other colleagues to join us, but in the meantime, we're just going to kick off the session. So anybody can go first. Faye, should we start with you?
Didn't we have some suggestions in the email?
We do, and some of them we're just waiting for some of them to come. I mean, I just thought we should wait for them to come up, join the meeting. But I'm looking at Rose's question. Chris, you've got something about referral list of advisors for settlement agreements.
Yeah, I'm happy to kick off. The suggestion was a referral list of advisors for the purpose of settlement agreements, and the context to that is other than an ACAS COT 3, it's the only way that an employer can enter into a clean break settlement and settles the statutory claims. So not the contractual ones, it's the big ones, the unfair dismissal, the discrimination. And what you see a lot, I think, particularly with the redundancy scenarios in the city sort of banks, is they tend to have a pool of local solicitors, sort of geographically close. There's no reason nowadays why that needs to be sort of actioned in quite the same way, but they have a sort of a short list, and they say to employees, here's a list of, or if you like, of specialists who undertake this sort of work. We know of them, they perform a service. You might want to look at these, and sometimes employees go with them, and sometimes they prefer to, of course, to use their own solicitors. And it just struck me that there was no reason why we couldn't have some sort of similar arrangement here, particularly where matters are likely to be non-contentious. Both sides are sort of working, so there's agreement in principle, if you like. That's I think it is difficult, and it's likely to be slightly invidious if you put forward a settlement which is going to sort of be inflammatory and likely to lead to litigation. So I can understand the difference where you don't necessarily, it's that usual worry about driving people into the arms of solicitors, but where all the signs are positive and it's a constructive dialogue, and it's a necessary evil as far as the client's concerned, they just want to go to somebody who will be sensible, look it over, give them any advice, and put the paw print on the document. It seemed to me there's something to be said for having a local forum where we could say, look, in that situation, you might want to look at those names.
Absolutely. And I think as HR professionals, we always refer to local, especially employees, we refer employees to local lawyers. So I could put what I could do is, with Dawn and Catherine, I could put together a list of particularly our members, the Seven Oaks Chamber members, and all the legal firms, and put that together, and we could share it on the website to say, where you're an employee and you would like to look at settlement agreements. Here's the recommended list. Is that what you had in mind, Chris?
Absolutely.
I think that's a very good idea.
I'm not trying to make it a consortium or a closed shop, or actually, I'm just trying to think it might be helpful.
That's what we do anyway. When we refer,
conveyancers often have that sort of relationship where they work quite closely. They recognise who they're dealing with, and often actually, I don't deal with local solicitors. It's quite funny. I almost think it's slightly odd, but I'm not coming up against the local solicitors.
No. But I think that's because most of your clients would be in the city, possibly, and that's where their network is, and that's where they're referring their staff to. because just like when I deal with my clients and with an employee coming up with a settlement agreement, I would refer them to our local lawyers. So I think a lot of that is driven by the employer.
Yeah, I would agree with that. But of course, all firms deal with clients across a broad sort of width, and we're dealing with specialists, or in different areas, different industries. We're dealing with people who have sort of very, very much more sort of standard jobs and so forth. So there's no magic to that. I'm rather surprised we don't deal with local solicitors.
I always think that, especially if I draft a settlement agreement for one of my commercial clients and I know that the individual lives in the area, I do find it I always fully expect to hear from another local solicitor, and I don't. And I agree. It's strange. I mean, I had someone the other day, it was an individual that he came to me, he'd been offered a settlement agreement, and he then came back to me again and said that his employer had advised him that they would only make the contribution if he used one of the lawyers on the list that he's being provided with. So I had to say to that individual, you can choose whoever you want to choose, but his employer kind of led him to believe that he had to choose one of those individuals on their list of preferred lawyers.
Yeah, which is what I was saying. I think we need to be careful how we word this on a Chamber of Commerce page. So we will say this is our recommended list of our members. Yeah, and you're welcome to approach any of them. I think we will make that pretty clear on the website. But yes, you're absolutely right. I think that choice is down to the employee. We should do our bit as a Chamber of Commerce, I think, to encourage people to use local lawyers. I can surely get that list together with Catherine and Dawn's help. That's a very good idea.
Yeah, I mean, the idea, I mean, I suspect because it's a matter of contract, and I don't think there's any statutory obligation to make a payment.
No.
It comes back to the usual push and shove, doesn't it? Because if somebody says, I want... I totally agree. We're on the same page, because you get that situation where somebody says, I want to use my independent person.
And you've got the employer saying, no, you want
the settlement agreement, you should make the contribution. But sometimes you get that on pass. But where I thought it would be really helpful is just, if there's something you don't like, for example, a tax indemnity or something that you think, actually, we don't object in principle, but we want to dilute it, or we want it broadened out or softened, or whatever it might be, an announcement, whatever it might be. If you can pick up the phone to somebody and just say, look, is there going to be any pushback on this? Or can we arrive at the same destination, but we're slightly different complexion? I actually think people would be more receptive if it's collegiate or collaborative, should we say, perhaps, in that sense. That's why I think it would work for the benefit of both clients. I'm not thinking it's one-way street. I think actually it could be a very constructive thing to do.
Yeah, it is definitely a lot easier when we pick up the phone and speak and iron out those sticky areas, isn't it? And it just gets things over the line a lot quicker.
Yeah. Because every now and again you pick up the phone and somebody says to you, I appreciate you don't know the background, we're not going to move one dot, this is it, take it or leave it, and we're not even going to enter into any conversation, and hearing that, at least it's informative. But normally you get somebody saying, well, okay, well, what are you looking for? Because actually this has already been subject to a lot, and you have a different engagement, but it can just be a constructive and sensible thing. And we're all chamber members, and it seems to me, I'm not trying to sort of lurch into different territory, but I mean, there is a sort of a collaborative element here that would work, as I say, for mutual clients.
Can I ask a question of Chris and Faye? When I always deal on the employer's side. I virtually never want to take on employee side for any work. And I'm dealing with this, and individual goes off, and generally we're doing, individuals. So we're not doing a mass redundancy where we would give a list, and would normally say to people, look, you need to go to a solicitor. And I always say to the employee or the employer, I would recommend you go to an employment specialist. Don't go to someone that did your conveyancing or granny's will, because they're more likely to know it, but you can go anywhere. how do solicitors view that work? And sorry, let me start again. I realise that's a very broad question, but in general, how do you view this type of work? Is it just, you know, this is fairly straightforward and I know it's going to be fixed fee, so it is what it is? Or do you look on it and think, oh, okay, or is it a case of, actually, we haven't met this person before, might be useful, might end up leading to other work?
I mean, sort of for us, I mean, settlement agreements are kind of our sort of bread and butter work.
Yeah.
So, I mean, we'll always, yeah, I mean, I would never kind of turn a settlement agreement down. And for us, it is all about kind of acting in the client's best interests and taking their instructions. We don't kind of just rubber stamp the documents and explain what they mean and get them to sign. We always take instructions so we can kind of ascertain whether what's being offered is fair and reasonable. So yeah, each case is different. We don't just kind of look at them as all the same. We do take each client's instructions.
Yeah, I would agree entirely with what Faye said. They often are that sort of more mundane, less challenging, if you like, from a legal perspective, and sometimes there can be a bit of a churn, and you can feel it's a little bit of a conveyor belt, and then you go through a slightly sort of more barren period. But it is important to act in the client's best interest, as far as the client's concerned. If you're acting for an individual, they've just lost their job, and unless they're in that happy position where they've got a back-to-back job lined up, it's actually a life-defining moment, and often sometimes you can find yourself lurching into sort of counselling mode, where somebody's trying to explain they've not done anything wrong, and you're saying it doesn't matter, you know. Yes, you know. So I think we're all astute to treat these things sensitively, but I think all solicitors, good employment solicitors, will give clients a good service. And I suspect as well, the spin on it is you recognise that there may be a new client, but that's not to say, as a marketing initiative, you don't get them in the door, show the firm off next time they become a conveyancing client, or they come back to you for work. So it's simply because it's a one-off small matter on a fixed fee, or often on that basis, doesn't necessarily diminish it.
No.
And what would you, in terms of how much an employer offers as a contribution, what would be your minimum, or do you have a sort of guideline minimum below which you wouldn't do it for, or the employer has to, or the employee has to pick up the rest? I
mean, we'll tend to, we see contributions ranging from, I mean, a few years ago, traditionally, it was kind of standard 250 plus VAT. Now we see contributions ranging from kind of 350 up to 750. If the matter, you can tell from the first phone call if it's likely to be contentious. You can tell from the way that the client's speaking about the situation. I would always kind of ask what the contribution is, kind of make an assessment there and then and say, yeah, I think this is going to be enough. If we do go slightly over, I'll cap my costs for you. Or if it does sound like it's going to be contentious, then I'll kind of give them the warning that in the first instance, we'll ask for the contribution to be increased. But if it's not, then the employee would be responsible for any extra costs. So, I mean, there's not kind of a minimum. If somebody came to me and it was a 250 contribution, I'd still take it on. But I'd assess the situation as to whether it was likely to become contentious and incur a lot of extra fees.
Yeah.
Yeah, I mean, again, I would endorse what Faye said. We probably do fix a minimum, because I reckon I spend 20 minutes, half an hour looking at a document or an email train, often into some background. So outside of the time spent speaking with a client, which is often can be a little bit of time, there's work done in preparing. I reckon these meetings take at least an hour, sometimes an hour and a half. So I would set a minimum of 350 from my own perspective. Often, to be brutal, that is significantly discounted in terms of time recorded, to be brutal. But I tend to fix the price to the value. If somebody's asking for 2 or 3 hours work and they're getting a very substantial package and they're leaving the city, I wouldn't see any difficulty in saying to them, look, the actual time cost is going to be at this level. your contribution is fixed, therefore the balance over and above that will be a matter for your own account.
Yeah.
On the other hand, on somebody who's perhaps with significantly less service and a very much more modest settlement, I tend to sort of fix it accordingly and cut my cloth. There's an element of Robin Hood, if you like, sometimes in my approach, because I think there's a sort of morality issue. If somebody can't afford to pay it, I don't charge it. But
people are losing their jobs at the end of the day, aren't they?
Exactly. And also, I mean, it's not lost on me that it is, from an employee's point of view, often they don't understand it's commoditized work. It's fixed price. They don't understand why they can't just sign the bloody document. They feel as though they're given instructions to a probate practitioner. They're coming in to sign the will and have it witnessed. And you have to actually explain to them, actually, it's more than that. And it would be the best money in the world if I could just sign a certificate, but I can't.
No.
I actually have to take your instructions and in light of those instructions, explain to you what the law is and your claims. Then once you understand that and you're happy to weigh them, go through it and start at the top and end up at the bottom. They tend not even to understand terms such as without prejudice and subject to contract. I mean, you literally start on the top of page 1 and finish at the bottom. So you can't really scamper through these things.
No, absolutely.
And I think there's only one way to do it, and that's to do it properly. And I'm sure we all buy into that because, A, we're specialists, and B, we're risk averse, and we want to do our best for our clients. And that's the mentality, isn't it?
I mean, and I suppose, Mike, from the employer's point of view, Faye is absolutely right. I mean, I remember we would all, 10 years ago, it used to be 250 plus that, but to think that it's only gone up by about £100 in 10 years. So I recently, just a couple of months ago, got a settlement agreement signed off. And the employer was not going to pay anything more than 350 plus VAT. And considering that there was really not much negotiation involved anyway, and I thought that was a fair price to reimburse the employee. And I think somewhere the advice given to the employer also incorporates, like Chris was explaining, how far is this going to go in terms of negotiation? Is there any element of negotiation really involved, or is it just, an open and shut settlement agreement? And based on that, you kind of advise the employer in terms of what should be a reasonable amount of reimbursement. And of course, in this situation, this employee did come back saying, no, my lawyer thinks it's going to cost more than 350. And we said, well, then you've got to foot the bill. And that was simply because we knew that this person was going to drag it out unnecessarily when there was really no grounds for it. So I think given the fact that obviously this forum is also for employers, it's important to emphasize that the advice given to an employer will also be determined in terms of what is reasonable for an employer to reimburse. And if that's 350 plus VAT, so be it. If it's 450 plus VAT, so be it. But it's got to be based on the merits and the demerits of the case.
I've always found it's during the negotiation, and you I think your words, Chris, was that where it's a non-contentious one, I think your words where it can be relatively mundane work because it's not. I have to say I find that this process actually is one of the more interesting aspects, especially when it's contentious. I find it actually probably one of the bits I enjoy most, which sounds really mercenary when you know what's involved. But I find the negotiation on the fees is a really curious dynamic. And let's say you've set it at 350 plus VAT, you can be going through a negotiation on 30 grand of a settlement, and they're asking for £5,000 more, and you say no, and they say, well, I'm not going to do it, I'm not going to do it. And then I speak to a solicitor and say, well, what's your fees up to? And they said, oh, we're up to about 800. And I say, well, okay. And then I say, well, go back to your client and say that we'll cover all the legal fees as long as they don't exceed 1,000. And then suddenly you get an agreement. And it seems that in all of the hundreds and hundreds of these I've done, the bottom line doesn't seem to add up, and adding money onto fees seems to count for a higher, more than adding money onto a compensation amount, which I've never understood, but it seems to happen. But I don't think people like the idea themselves of writing a check to the solicitor.
Yeah, they don't.
But, so you can settle for an extra 500 quid in fees, but they wouldn't settle for, for another £3,000 on compensation,
Yeah.
which is weird.
I mean, I think a lot of employees have the mentality of kind of my job's terminating through no fault of my own. I've been told that I have to get this legal advice, so why should I have to pay for it? I think that's what a lot of people think. Yeah,
Absolutely.
Yeah.
Absolutely. I mean,
Absolutely.
I was when I'm advising clients, I say, you know, you can add on to legal fees and get a better settlement than if you add on to compensation.
I think that's right, Mike, because the perception is from the client, it's not their problem. They're
Correct.
being required, and therefore sometimes they undervalue it. But often when you're at that sort of take it or leave it stage, they're staring down the barrel of what is sometimes quite a harsh reality. So there it is. On it may not be everything they want, but it is a relatively, proportionately a sensible commercial settlement, and the sort of costs factor, if you like, or the pros and cons of pushing it further and it blowing up to the point where they end up with no settlement, out of job, and then having to commence a claim, particularly in the sort of regime at the moment, it is unattractive, and there's no appetite to do that. So once they've got to the point of pushing the settlement as far as they can, then it's about consolidating, and the legal fees then have a higher importance because of that.
Absolutely.
And there's, I think probably it's not lost on employees that you know, they pay VAT on any balance, so the cost to them is, particularly if it's coming out of a net sum, when they've already had tax deducted, is that double whammy. They're sort of they're paying legal fees with VAT added from a payment in lieu, which is taxable. So it's unappetizing.
But if the fees exceed and the individual's having to pay, I always recommend at the end, as part of negotiation, that we move money from compensation onto legal fees, so that A, they don't get hit personally with the VAT, but also if it's in excess of 30,000, then they're taking it out of, in effect, it's not, they're not losing money from taxed income.
Absolutely, I think that's a very creative thing to do. I mean, it's because over and above the 30,000 threshold, it's tax at source anyway.
Absolutely.
You're actually, and because the employer can use it creatively and set it off as a business expense under the revenue exemption, it's a win-win for both sides. So it's a neutral change, but it's beneficial.
To go back to your original question, Sandhya, about having a list, I also think the advantage of having a central list, rather than, for example, me saying to a client, why don't you give Faye or Chris a call, is that it's then another step removed from us, not necessarily recommending them, but saying you could look at, rather than it being, and I don't know if you're thinking it to then go on the website.
It will be on. I think obviously
Fine.
it's me. This is me saying it, but I have to get it signed off by Dawn. But I just think it's a good idea, because that's a good way of signposting an employee who's already not in a very happy place. Rather than them having to go around, shop around, ask a friend or a neighbor. We just signpost them to the chamber website and say, look, there's a good consolidated list of locally well-known solicitors, whom the chamber recommends, and so it's one good place for you to start.
Absolutely.
Absolutely. So,
and I think that's easy. I think that would be easier for someone, say like Kerry or Ros or myself, to then refer to the chamber rather than an individual, because it then still has that additional level of removal.
And still, like Faye was saying, it keeps it neutral, because you're not naming one particular area, but you're giving them the choice. Which is exactly what we should be doing.
It's also very important that apart from free choice in the market, the solicitors having to certify that they're independent. And so the fact that the referral or the link may originate from, if you like, a friendly and well-known source is neither here nor there. At the end of the day, you're still acting for your client's best interests. And it would have to be on the basis that if the advice in a particular situation was actually, I think this offer is ludicrously low. It's not at all proportionate, and actually you've got very significant claims which have not even been taken into account. It could go off in a totally different direction. I mean, I think everybody would have to understand that. I mean, it's certainly not a shoe-in that everybody would just simply rubber stamp it. And I think everybody looking on behalf of their clients at settlement agreements would approach it very deliberately and conscientiously in the usual way.
But it isn't just that declaration of the independence; it's also a perception issue from both sides as well.
Yeah.
Yeah.
Can I ask a question? Just coming back to the thing about the fees and whether you do it on a fixed fee and who pays for what legal fees. What are your thoughts? So quite often I'll have conversations with clients. I'll say, well, normally the kind of set fees are around about 350. If you're in London, it might go up a bit higher, but generally that's the fixed fee, and that's what we'd need to put into the settlement agreement. And then we end up in some sort of protracted negotiations, because obviously they've had advice that says, you need to ask for more because you've got this, that, and the other case potentially, etc., etc. Where is the line between an employer feeling that they are paying for someone to get legal advice, which is directly opposed to their own interest, that they are gonna, they're gonna have to pay for? So the 350 is a blanket fee, supposedly, for an employment lawyer to say, this is what the document means, this is what you're signing, do you understand this document? Yes, okay, let's sign it then. It's about making sure that the employee knows exactly what they're signing away, right? It is not payment for that individual client to bolster their own compensation, because why would an employer pay for your legal fees to get more money out of me? And it's always this massive conundrum, because I had it recently with that nightmare case that I wanged on about for ages the last time we were on, and the fees were just going up and up and up, because it was a completely complex case and he didn't have the money, but quite often you'll get individuals that are prepared to negotiate directly with you or with the HR person or with someone like me, rather than having the lawyers do it, because obviously then it means that the fees don't escalate. But he wasn't able to do that, and we did end up paying a lot of legal fees because we felt that was appropriate. But where's the line in that? Why should an employer pay for an employee to get advice that's contrary to their own interest? What are your thoughts on that conundrum?
I mean, with the contribution of, I think because it's a legal requirement for that individual to get independent legal advice, and for kind of me, when I'm advising an individual, I wouldn't be doing my job properly until you have to advise them of the potential claims that they might have by signing the document. And there is always a risk that sometimes employees come to you and they say, oh yeah, it's very, very straightforward. But for me to sign my advisor certificate, I have to be comfortable that I've kind of given them full advice. And then sometimes they say, oh, well, actually, can we go back and make a counter offer? At that point, I do say to them, we'll ask your employer if they will increase their contribution. If they don't agree to it, then in the first instance, I'll be happy to cap my costs. But if we do get involved in kind of protracted discussions, then I advise the employee that they will be responsible for those costs. I mean, with employers, sometimes they just want to kind of take a view on the costs if it means that they're kind of putting an end to a contentious relationship. Sometimes employers just kind of agree to increase. I think it just entirely depends on the situation. It's really difficult to say sort of where the line is drawn. I think for me, when I'm advising an individual, it's just all about transparency in terms of the costs and making them aware of the situation. If the employer isn't agreeable to meeting their legal costs, especially if you go off and get them kind of, if the compensation is increased, and then you can't have the employee saying, well, I'm not paying you anything, and when you've gone and kind of negotiated them a higher sum of money. So yeah, I just always make sure that I'm transparent with the individual with regards to what the situation will be if the employer is not willing to match that, to meet all of their legal costs.
Yeah.
I mean, Ross, I think frequently, it's a source of friction, isn't it? Because you've got what should be a common purpose, but only if both sides are on the same page and holding hands and walking in that direction. And often you get an individual who turns up and says, yes, I'm agreeable in principle, fine. And then actually, as you start developing that conversation, you realize they don't really understand it. And actually, either they're not terribly sophisticated in understanding the value of the claims or the strength of their position, or actually there are things they should sensibly be asking for because of the circumstances. So things can sort of morph and develop, but essentially from the employer's perspective, because we act on both sides, I'm sure we all do. If you want to be a little bit more brutal and a little bit more commercial, it's not an indemnity.
No,
it's a fixed contribution with a view to getting the solicitor's certificate, but you don't necessarily have to pay it all. And in fact, there's no requirement to pay a penny. The convention has arisen because you can only achieve, unless you go through a COT3 through ACAS route, you can only arrive at a binding clean break settlement if you use it and the prescriptive obligations. And what individuals tend to say is, I'm happy to sign it, but I'm not going to pay a solicitor if everything else is agreed. You, the employer, should pay for that because it's ultimately for your benefit. So that's sort of the starting point, I guess. But it's without prejudice, subject to contract. And if the fees, if the fear is that the fees are escalating dramatically out of proportion to any sensible dialogue, it's always possible for an employer to sort of push back a little bit and say, look, I don't want there to be any misunderstanding here. We've just been very open, very candid, albeit on a without prejudice basis. This is fixed. You can take whatever advice you like, you can see whoever you like, you can take a second opinion, you can do whatever you like, but we are only going to contribute X. And unless you put a very, very good and forceful argument as to why that should move, that's staying, that's in tablets of stone. But we'll look at other points and we'll see if we're not slamming the door. We'll be accommodating if we can, and we can push on other things or whatever. But there's certain points here which are not going to change. And it's the tone that is set, I suppose, and the dialogue that then follows, because there are those instances where you can only get something across the line with a large degree of input and investment in terms of time and support from both sides. I'm not singling out what one's representative, but
I think that's the thing. It's kind of everything's assessed on a case by case basis. If you've got a very kind of standard situation where it's not contentious and it should just be a case of going through the document and getting it signed, then why should the employer increase their cost contribution? So yeah, with commercial clients, we always say to them, kind of, this is the standard contribution. They might come back and push and ask for more fees, but you can say, no, this is what we're offering, take it or leave it. And then it's down to that individual to liaise with their own lawyer about whether they're willing to kind of meet their extra costs, or if that lawyer is happy to cap their costs.
I've always found, sorry, after you. I've always found that actually this aspect is one of the more useful ones in terms of negotiation, because when they're saying, yeah, but I'll get the employee or you more usually the solicitor saying, yeah, but I've had to go into all of these extra discussions to tell them about potential action. I said, well, that's not what we're paying for. We're paying for you to advise them as to the rights they're waiving and to their potential actions. It's not to help them construct a case. And also, I'm assuming, Ros, that your settlement agreements all say we're only paying this if you sign. Because yeah. So I mean, that's another, I find, it's again, when I remind them of, look, we don't sign, the employee pays. We don't pay. Yeah. And so I find that, but I also advise the client, say, look, sometimes, go back to my earlier point about the money, sometimes it's worth you know, if you're talking on a £40,000 settlement, ironically, another £500 or £1,000 on the fees actually will get you a settlement quicker. So I think it's the advice on both sides. It's and a lot of times it's taking the emotion out for both sides. So it's saying to the employee solicitor, look, I know they're upset. I completely understand that, but we're not here to discuss whether or not they're upset. We're here to try and get a legal agreement. And I say to the employee the employer who's up in arms at the injustice of the world, and just say, look, you know, this is all very interesting, but you're paying me, and you know, all this is doing is increasing the cost. So what outcome do you want? Do you want it to be absolutely fixed, no movement whatsoever? Fine, that makes it easier. Or do you want to get a settlement? Obviously, said with a great deal more charm.
Yeah, and persuasion.
I think, Rose, equally, it's just, you know, it's about setting expectations straight at the very onset, because nobody likes surprises. It's already quite an emotionally heavy, you know, circumstance to be in. And I think when emotions are involved, it's our job, and I see it as my job, to really set those expectations and those boundaries. Yes, there's negotiation, but I think negotiation has to start with some boundaries equally.
Yes.
And it's about laying that out clearly to say compensation for legal fees is you know, this is a fixed fee, and and you know, this is what we are offering. And we don't even have to offer, but obviously we don't say that in such a blunt manner, but we make it very clear that it is a fixed fee. And I think that way the expectation is almost, so when they come back and say, oh, can you give me 50 quid more, because, or 100 quid more, they will think twice before doing that. And I find that it helps to kind of lay it out very clearly, but politely, and be very honest without prejudice.
Yeah, completely. Okay. Sorry.
Do you enjoy doing this work, Ros?
In a perverse sort of way, it's quite satisfying when they eventually sign, and it solves the problem for the client, because that's mainly what it's about, isn't it? The client's got a problem, they need to solve it, and this is the way that they want to solve it. So by doing that, it's quite satisfying. But I get a bit, if it's a complex case and there's shades of grey, I find it quite challenging on a personal level, because you feel for the person who's in that situation, and you want to sort of make sure that they're being treated fairly. So yeah, it's a tricky one sometimes. It's tricky. Start the job though, eh?
Yeah.
We haven't heard from Kerry at all. Do you want to unmute and tell us what's happening in your world?
I certainly couldn't add anything to that, but it was a fascinating discussion. And I certainly, I mean, just to go back to sort of the original basis of the conversation around providing that list, I think and from the sort of employee's point of view, anything that helps them feel more comfortable, feel more knowledgeable about the process, the situation, access to information, you know, from that employee point of view about their rights, what they can access, what support they can get is great. So yes, brilliant. A list of sort of tried and trusted solicitors who are there to help them, I think, can only be a good thing.
So I think it's giving that employees who have been offered a settlement agreement, they feel like they've sort of completely lost control. So I think that's why a lot of people, if an employer gives them a list, that's another element of the transaction that's being controlled for them. Whereas actually, if they know that they can go somewhere, make entirely their own decision about who they use, rather than feeling like the employer's kind of pushing someone on them, then I think that's that's
I agree, definitely.
Useful. Chris, thank you very much for that input. It's definitely been something that's got us thinking and something for us to do. We've got a question on, the person is not here, Kate Jackson from Liam Coachwork. There's a question about dealing with difficult conversations and confrontation. Now, I know that's extremely broad, especially for other HR professionals, because we come across that all the time. I mean,
dealing with what, sorry?
Dealing with difficult conversation and confrontation. All I will say is, on that topic, I think one has to guess there's a lot of discomfort in having those conversations. That is the default situation for many employers is, you know, it is difficult for them to have that conversation, because especially in a small business environment, it's people are within the same community, your friends, you know, it's that very cozy, comfortable feeling, and having those difficult conversations is just, you know, something that they would rather not be doing. And I find that one way, two actually ways, is one, having that neutral party to intervene, like somebody like Rose, Mike, or myself, to intervene there and take that burden off their shoulders and remain that neutral party who's keeping that relationship going, but for the right reasons and in the most objective manner, taking the emotion out of it. But secondly, equally, I think it is also an element of providing that training and awareness for managers and people who are in that position to lead. Just to and there's so many aspects to it. I obviously not, you know, it's not something that can be covered in, you know, with a roundtable, but training definitely is an element, and these are all aspects that help to nip issues in the bud before they can completely snowball out of control. Anyone got any inputs there?
Well, I mean, there's definitely a, so just because you have to have a difficult conversation doesn't mean it has to be unpleasant. So there is a right way and a wrong way to have a difficult conversation, isn't there? And I think that's where the training comes in. You know, and some people just don't know how to deal with difficult situations. I had, at one point, there was a manager that I supported when I was in-house. This is many, many years ago. And if she knew she was likely to be having redundancy conversations with people, she would not make eye contact with them for almost like a week before. So, because they just don't know they can't live with themselves because they know they're going to have to deal with this, but they can't sort of elevate themselves up to a higher level. And, you know, so it just made that when the conversations did take place, it was worse because they felt like they'd completely ignored, and it was a personal thing and all of this. And it's just like a bit of training on that kind of stuff just goes a hell of a long way in terms of stopping all of that. You know, it's about being professional and delivering it in the right way. And if it needs to be, you know, difficult conversations cover so many different things. It could be anything, couldn't it? It could be a conversation about personal hygiene, or it could be telling someone that they've had an accusation of harassment against them. There's so many different things that are covered by difficult conversations. It's hard to sort of, you know, generalize, but I think just being professional enough to really think about what you're saying to the individual, and with the backup of the training, and obviously advisors such as ourselves to help them prepare in the right way, and try and prepare for any sort of curveballs that might come. You know, when you've got lots of experience of supporting people through difficult conversations, you quite often know the things that do come up, so you can kind of help to you know, be proactive in terms of guiding clients and say, well, if this comes up, then this is how you need to deal with it. And if that comes up, if you're not going to be in the conversation itself. So yeah, yeah, that's my experience anyway.
I think from as well, often these things, from an employee's point of view, a difficult conversation can often escalate to a grievance, and then you're running sort of in parallel. From an employer's point of view, therefore, it's very important to have control and to make sure that what you're discussing and the points you're raising are dealt with in a very deliberate and measured way, and while you're listening and taking on board what is being said, actually you're communicating effectively and sufficiently the point you want to get across. Because I think, Ros, you're absolutely right. The danger is, you know, people, for example, in a redundancy, you know, you can see it in companies when they've been through 2 or 3 redundancy routes. The HR people are very much more, they become inured, don't they? They become much stronger and more resilient and more robust in how they're going to present that information. But the first time round, there's a lot of you know, the eye contact is gone, the voice is faltering. It's because it's embarrassing and it's hurtful. It's not why people wanted to go into that role at all. Quite the opposite. They want to support and promote people and so forth. So it's having to get over that hurdle, isn't it? In a way, and there's that sort of parental aspect that you do need to have control. In a loose sense, I just mean, I don't mean sort of in an overly authoritative way, but you do need to have a measured delivery and a clear agenda, and your expectations and your aims and objectives are paramount. If the meeting is going to have a proper resolution from the employer's perspective, I think the flip side to that is, you know, the employee needs to consider their options and see what is, and assess whether it's credible, you know, and whether whatever it is can be addressed.
Whenever I'm speaking with clients about these types of issues, I always say to them that in my 30 plus years of doing HR, I can still remember the one opportunity, the one instance when dealing with the manager on a contentious issue, and the manager said, "I think we did that too quickly." Literally one instance in 30 years. Every other instance is, I should have done that 6, 9, 12 months ago. And I always say to clients, you know, if it feels like it's too early, it probably isn't. And the more you leave it, the more you leave it. Now, I understand why you leave it, because it's a natural human reaction to avoid confrontation. But again, you know, and I still remember the case once in 30 years, literally, and maybe there was others, I don't know, and I just say to clients, and the other thing I would say to clients as well is, what's the salary? Because if I get a call from someone, oh, we're having a problem with this and this, what's the salary, right? Cost of benefits, right? 50,000 a year salary, it's probably costing you the equivalent of, I don't know, 5 grand a month, all in, 6 grand a month, all in, right? Every week you're waiting on that, tick, 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 tick. There's your extra money. And if you're thinking of getting rid of them, or you're thinking of having a conversation, every month that you're leaving it, tick, 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 tick.
There's also the procrastination element of not wanting to have a difficult conversation, in the sense that so many times people, they put things off because they don't want to do it, but the problem is still there for them, and they're still obsessing about it and worrying about it. And then as soon as they've dealt with it and they've had the conversation and things have moved on and everything is much more positive, say, don't you feel so much better now? It wasn't nice, but it's dealt with now and everybody can move on, and it feels so good. And so if I work with clients for a long period of time, we have those experiences together, and I can then refer back and say, you know, we've had this before, it's not going to be nice, but let's do it in the best way possible we can, and then everybody can then move on positively. And the relief that they feel once they have actually addressed it is so significant that it does really stay with them.
Yeah, I think, Rose, on that point where you kind of walk that path with the client, linking to what Chris was saying earlier, usually the first instance when they've decided to just push it under the carpet and not deal with it for a long time, it does fester and it ends up as a grievance, and then you go down an appeal, then a settlement agreement, and a possible, if there's no settlement agreement and they won't sign it, then, as you know, it drags on. So it ends up being a negative experience for the employer. But that negative experience, we reflect on that and we look at lessons learned. So I wouldn't say that pushing it under the carpet and not dealing with it and ultimately having that conversation ends up being a totally positive experience for the employer, because I think the timing when we initiate that difficult conversation after having pushed it under the carpet for a certain amount of time is crucial on whether that's going to be positive or a negative outcome. But ultimately, both ways, whether it's a positive or a negative outcome, I think the result, there are lessons to be learned, and definitely an employer who has walked that journey with an HR professional already once, regardless of the negative outcome being positive or negative for them, I think they definitely reflect on that and they are more willing afterwards to have those conversations earlier, or allow an HR professional to have that conversation for them.
Yeah, because I think it's also about if they're procrastinating and delaying, and they say, "Oh, I don't want to do it yet. I don't want to do it yet because I want to give them the benefit of the doubt, or I want to do this, I want to do that," and say, "Well, okay. In the meantime, you need to deal with them in the correct manner," because the danger is, of course, that they've got this, whatever it is, festering resentment or annoyance or whatever it is that's building up inside them. And then the next thing you know, there's been some sort of horrendous explosion where they've just lost their rag with this person. And it's a management failing because they haven't had the conversation right at the beginning to say, this is wrong, that's wrong, what are we going to do? Let's work together, support you, etc., to improve. And then if there's no improvement, then deal with it in a, whatever way is appropriate at the time. But that's it. They have to understand that by delaying, that then affects how they then need to deal with that person, because until you raise it as an issue, they're not mind readers. They don't know why you're treating them in this way. And that's when you get the grievances in. So-and-so ignores me, never says any good morning to me in the morning. He says good morning to Joe every day, etc., etc. I'm being victimized, blah, blah, blah. And because they can't, there's a consequence to procrastination as much as there is a consequence to dealing with it at that moment. So it's often it is really challenging. And like you say, Sandhya, if you procrastinate and then you deal with it, yes, people do move on, but it's not a pleasant, and it can be a negative experience, and it costs more money probably.
And it does mean that support, that training, not just the support that as an HR consultancy you can give, but that training for managers and leaders around how to tackle those conversations, how to prepare, how to build rapport, how to be resilient, even training around managing their own feelings of stress and anxiety about those conversations. Vitally important, I would say.
Yeah.
I also think it's worth trying to. Sorry, Chris, after you.
Oh no, go on, Mike. Sorry. Okay.
You won't talk.
Well, I'll go first, and then I was just going to say that there's also, I mean, it shouldn't be lost that there is an extra benefit sometimes in having such a conversation if it's forthright and honest, and sharing information which might not be welcome, whether it's redundancy, capability, capacity, disability, your performance, hygiene, as you mentioned. I mean, whatever it, because that myriad of difficult things that in any employment situation can arise. But as soon as you've got an issue and dispute, then you can have a without prejudice conversation. Without the issue, you can't. So the typical situation, you start the redundancy and then you slide across to without prejudice offer, works because they're in tandem. You can't have the without prejudice dialogue per se without the issue. You can have the section 111A protected conversation, but of course that's ring fenced only for unfair dismissal purposes. So as soon as you've got any discriminatory aspect, that doesn't work. So you've got to have that duality, that double approach, as it were, that in parallel. And so I'm not saying an altercation, but so we say a robust and candid exchange of views, which is sort of actually sometimes can facilitate a without prejudice offer, because actually what you're trying to say is, look, there's a huge and almost insurmountable issue now between us. One option and a viable one to resolve that is to end up in a different solution, and so it can actually be a means to an end as well, tactically, strategically. That's what I mean. Sorry, Mike, I sort of
I think I'd also add the two questions worth asking of the manager in that circumstance. One is, what outcome do you want? And if it is, on the basis of, does the individual is there any indication in the trajectory that this person can achieve what you want them to achieve? And if the answer is yes, I think so, then the next question is, what is the downside? What's the downside of having the conversation now? Other than if there's the key client meeting on Thursday and you're talking on Wednesday, that's one thing. what's the downside of having it now? And then and if the answer is, I think this individual has no chance whatsoever of achieving what we want, and frankly, I don't want to keep them, I then say, well, in that case, think about whether or not you want to keep them. And if you don't, act on it quickly, because trying to put them through a performance plan where you've no intention of them succeeding will be seen through. You know, that those never work in my mind, ever. But then the second thing is saying to the individual, what are the worst scenarios you can imagine of having this conversation? So if you're going to have an argument, or if the individual is going to have a meltdown about it, is it going to be any different now or in 3 months' time? Is it going to be the same meltdown? You know, now if their mum died last week, absolutely fine. That's a really good reason to delay it. But is there a downside to having the conversation now? And what are the upsides? And then it's also, but there are also some individuals, I think it's also reasonable to say some individuals, you could put a notice on the front of their computer, you could drive a billboard outside the office saying, we don't think you're ever going to make it. And the individual will come out of me and say, oh, I think that went quite well. You know, no, I think it's all looking really good.
Yeah.
And you have to raise your level of bluntness and explicitness to suit the individual, or reduce it appropriately. But you're right, it's not easy.
Very interesting conversation. Thank you so much for all your inputs, your advice. I'd love to continue the conversation, but we can't. So just going to wrap up the session today. I think we've discussed two really good topics.